how are you all doing? Today we will have the online discussion on the final exam coverage for our subject law and obligations and contracts, or Oblicon, or business law for my BSBA or business administration sophomore students in the State University, Alubijid and Baungon campuses. I've already actually recorded this one earlier, but for some technical difficulties I was not able to save everything, so I am doing it again this time. So for my students, please bear with me because my voice is not that good today. I'm under the weather, if you call it. So anyway, for my students, please have with you your finals module so that you can get along as we have our online discussion this afternoon. Please remember that the finals module was already uploaded in our Google Classroom. So for those students who were not yet enrolled or who have not yet joined our Google Classroom, please do so because you can only access the finals module in our Google Classrooms as well as our midterm modules and prelim modules. So please follow instructions. Again, I've been telling you many times, please follow instructions. Please read everything so that you can follow our discussion and our subject. We have only a few weeks before we wrap everything up this semester. I will no longer discuss with you the final coverage of our subject because that would take us 3 to 4 hours, imagine, because it's very long. But I assure you that most of the questions that are covered or are included in our finals exam were actually covered from our midterm examinations. That was why I wanted you all to have perfect scores for your midterm exams. But for some reason, not all of you were able to get the perfect score, so I am having these final exams for you. So don't fret. The final exam is just a recycle. It's a recycle. Some of the questions are recycled from our midterm exam coverage or questionnaire. So again, instead of discussing with you the entire finals coverage in our module, I will just show you the questionnaire, and then it will be up to you to get or to answer the correct answers. For those who are exempted, please guide your classmates who will be taking the exam because this examination is open notes. Again, it is open notes, and you can only answer through the Google Forms that I will open by next week. That's May 19, 2021. For those students who will not be able to take the final examination but were required to take the final examination, will not have the final grade. So please follow instructions, ladies and gentlemen. Let's proceed to our online discussion of our final exam coverage for our subject, obligations and contracts, business law for BSBA second year, xoxo students. So this is how our final examination questionnaire looks like. It consists of 52 items, okay? 50 are multiple choice questions and 2 are short essays. The total score for this examination is 120 points. Again, the total score is 120 points. For those who are already exempted, okay, I already gave you 120 points for the final exams. Now please read carefully all the questions and choices. Do not leave any item unanswered, and you are given only 2 hours to finish this exam. You can only answer once. Again, you can only answer it once, and so you have to review your answers before you submit. No more retaking of exams. You have to take the exams using the Google Form. Okay, let's go to our activity 1. So activity 1 is multiple choice questions. The total points for this activity is 100 points. So we have here question number 1, which is just a recycle of our midterm exam. So you have to choose here, of course, because this is already a recycled question. I just changed the names of the characters. You have to choose here which is the correct answer for this question. This is a question about paternity. There's a hint here about the character, one of the characters, the mother, who already filed for support. When you say filed for support, the mother already filed for a civil case against the biological father. So there was already a paternity testing, and in that DNA paternity test, it turned out that the father and the daughter, Donna, their DNA actually matched. So here you have to choose which among the choices is the correct answer. Of course, the answer to this will be DNA test. Okay, the DNA test that the father really has to support the daughter. Then you just give the reason and choose among the choices. Number 2, this was already discussed during the midterm exams, so it's up to you which of the choices is the correct one. It has, the question is about true or false, criminal act gives rise to civil liability. Number 3, this was also discussed during the midterm exams. So it has something to do with mora. So mora, when you say mora, it has something to do with default. There are two kinds of delay, by the way. There's ordinary delay and we have the legal delay. When you say legal delay, this already pertains to default. When you say legal delay, there are 3 things that you have to bear in mind. It's either it is mora solvendi, mora accipendi, and compensation mora. Compensation mora, that parties to a contract or to obligation are both in default. Okay, so who are the parties? Again, they have the creditor as well as the obligor. They are both in default in compensation mora. So their liabilities would be cancelled depending on the gravity of their default. And then we have mora accipiente. When you say mora accipiente, from the term accipiente, the one who should accept. Again, we go back to the definition of obligation, right? So when you say obligation, okay, when you say obligation, we talk of the elements of obligation. There are 4 elements, remember? So when you say elements of obligation, we have the active subject, passive subject, and then the prestation, efficient cause. From the term active, okay, active subject, he or she, the creditor, is the one who demands the performance of the obligation. So by that term, demands, okay, so he should be the one who will accept. That's why when that person, the creditor, is in default, the term for that is mora accipiende. Then the other kind of legal delay is mora solvendi, because he is the one who should perform the obligation, and the one who performs the obligation is the obligor. So in mora solvendi, the debtor, obligor, is the one who is at fault. So which among these choices is the correct answer to number 3? Because it is the obligor who fails to deliver the thing. And then we have number 4. This was also discussed during our midterm exams. So we have here the right of subrogation. So what is subrogation? Subrogate, so nag-step in siya sa shoes ng isang tao. So which is the correct answer? Is it novation, compensation, payment, compensation, or compromise? So you have to choose which of these. I already told you the answer before. In number 5, in an obligation to give a parcel of land subject to suspensive condition. So when you say suspensive condition, you're talking of a condition wherein the happening of that condition is the reckoning point when you will start to perform the obligation. So if that particular condition is not yet there, it did not happen, then you don't have anything to perform. So you have no obligation to do something. But the happening of the event or the condition would be the reckoning point within which or upon which you would then perform the obligation. So if that's the case, from the time, let's say, from the time that you just have to wait until the coming or the happening of the suspensive condition, who is entitled to the fruits? Is it you, the buyer, or is it the seller, the one who sold the fruits to you? Because in your case, if that condition didn't happen or has not arrived yet, then you are not entitled to the fruits. So since you are the buyer, you are not yet entitled to the fruits. So it is the seller who has the right to the fruits. Number 6 is any event which cannot be foreseen or which though foreseen is inevitable. So it is something to do with it's either you have 2 options. It's fortuitous event or force majeure. When you say fortuitous event, this has something to do with the act of God. You have no control over it. No human intervention could do it. So that is fortuitous event. When the event that would excuse you is an event which is an act of man, okay, there's human intervention involved, then it's called force majeure. So which of the choices is the correct answer to this? Event which is foreseen or though foreseen cannot be foreseen, or though foreseen is inevitable. So an example to this are natural calamities like typhoon, tsunami, earthquakes, or volcanic eruptions. Those are things which are actually cannot be foreseen, or if they're foreseen, even if they're foreseen, you cannot have any control over it. You cannot stop it. So those are fortuitous events. Number 7, this was already tackled during our midterm exam. So it has something to do with land being delivered to the buyer, but the buyer has not yet paid the full amount. So there's conditional sale involved, and in this case, the buyer was not able to pay the full amount on the date that was specified in their contract. So in their contract, that contract is conditional sale. So does the seller have the right to file a case for rescission? So that's the question. Which of the choices is the correct answer? Of course, the answer must be yes. Rescission is the proper remedy. Okay, why? Because when you say rescission, it means to say one of the parties already violated the terms of the contract. Okay, so in this case, Ellen was not able to comply with the terms of the contract, just violated the terms of the contract. Considering that she says here she's not sure when she would be able to pay the amount, and then the time already arrived, it's more than 2 years, but she was not yet able to settle the full amount, so the other party can rescind the contract. The number 10, if the thing to be delivered is lost due to the debtor's fault, so it is now again the debtor's fault. Debtor's fault, why the thing that he is supposed to deliver was lost. So in this case, when you have this thing lost due to the fault, okay, there was fault on the part of one of the parties. That party should do something like pay the amount or pay for the price of the thing lost plus damages. So which among the choices here is the correct answer? Number 11. Rafi was depressed this past few days. So in this case, this was also tackled during our midterm exams. This was covered in our midterm exams. So this is a clear case of solusio indivitis. Now, when you go to your finals module, okay, you go to your finals module and then you just right there, if you are using a laptop, you say solusio indiviti, okay? This is an example of quasi-contract, okay, solusio indiviti. Now, you don't need to memorize everything because you have your modules and this examination is open notes, okay? So when you say solusio indiviti, this is a case wherein someone received something when he has no right over that thing and he has no right to demand it, but it was unduly delivered or deposited to his account by mistake. So there was a mistake. Now he has to reimburse, or he has to deliver, or he has to return the money that was illegally or unlawfully deposited to his account or erroneously deposited to his account. But then he didn't know who was the lawful owner of that amount, 16 million. So what should he do? The answer to this is, of course, he has to report the incident to the bank, and of course he has to return the money. Otherwise, there would be a clear case of unjust enrichment on his part. Let's proceed to number 12. So this is true or false. The debtor, under the law, has the right to choose which among the prestations he has to perform. If there are more than one prestation he has to perform. But in this case, there was this mention, it was mentioned that he has to choose those prestations which are impossible. Of course, he cannot choose those prestations which are impossible, unlawful, or could not have been the object of the obligation, because this would defeat the very purpose of obligation or the contract. Because he has to perform, right? He is the passive subject and he has the obligation, he's obliged to perform the thing, the prestation. So if he has the right to choose those things or prestations which are impossible, then how can he perform his obligation under the contract? So this is false. The answer to this is false. Number 13, okay? So who is this person who is demanding performance of the application? When you say the person who is demanding the performance of the application is the active subject. So the active subject is the creditor. Number 14 to 16. Susie is an obsessive compulsive lady. This was also mentioned or covered during our written examination. So you already know the answer to that. And then what is this case? Okay, 14 to 16. What do you call their situation? So this is a clear case of negotiatorium gesture. So you go back to your modules, okay? It says here that negotiatorium gesture is an example of quasi-contract, which refers to the juridical relation that takes place when somebody voluntarily manages the property affairs of another without the other person's consent or knowledge. Okay, now the person who does this thing of voluntarily managing the property affairs is the gestor, and that gestor is also entitled to be reimbursed for the necessary and useful expenses that she or he incurred. In this case, Susie is entitled for reimbursement for the necessary and useful expenses that she incurred when she cleaned the lawn of Carl. Okay, this is supposed to be Susie and Carl. Number 18. Demand is not necessary to incur delay when time is of the essence or when time is the controlling motive. Why? Because if you say creditor refuses performance, there's no such thing as you cannot demand anymore. You should demand, right? So time is the controlling motive because in the contract, for example, it wasn't already indicated there when you should perform the contract, and you don't need to demand that person to perform the contract because it was already stated in the contract when he should perform the contract. So the time is the controlling motive. Number 19 to 21. So this is the case wherein the other party, one of the parties, was told to sue the dress for another person. So this person, the parties here are Allison and Sandra. Sandra was the seamstress and Allison was the alleged customer. So in this case, Allison refused to accept. She was the one who refused to accept the dress that the seamstress offered to or delivered to her, because according to the person here, Allison, she found another dress much better than the dress that Sandra offered to her. Now, can Sandra insist on Allison to pay for the dress? We have here the choices, so it's up to you to choose which among the choices is the correct answer. Bear in mind that we are talking of law and obligations and contracts. There are some points here or choices here which says that she cannot insist on Allison to pay for the dress because there was no contract. Actually, there's contract because we have the essential elements of contract. What are the elements of contract? We have three: consent of the parties, then the object, and then we have the consideration. In this case, these three were present in the case of Allison and Sandra because even if there was no written contract, there was verbal agreement between the two of them, right? And the object here was the dress and which must be delivered to Allison the following day at noon. And the consideration is of course the price. So there was a contract. Number 22. It is a juridical relation resulting from lawful, voluntary, unilateral acts by virtue of which parties become bound to each other. So the reason here is that although there was no contract, but because there's this reasoning that no one shall be unjustly enriched or benefited at the expense of the other. This is a clear case of outside contract. So number 23. What are the essential requisites of contract? It's there, COC, consent, object, and the consideration. Number 24. It is a mode of extinguishing an obligation when two persons their own right are creditors of each other. So what is the answer to this question? What is the answer? We have here the four choices. When you say novation, this is actually a mode of extinguishing obligation, but the terms and conditions, the terms in the contract, terms and conditions of the contract are irreconcilable or they're incompatible with the previous conditions of the contract. So in this case, can we say that there was incompatibility? No. Then you go to compensation. Compensation is that there's payment, okay? Payment, you have the other person paying for the other, and then later on that person should also perform the obligation of their agreement or their contract. So in letter C, reformation is that you have to amend the contract itself. Confusion is that the creditor before is now the obligor of himself. So it's like you pay, for example, another person, you pay him or her, you issued a check, for example, to another person, and then you wrote it in the check, the word cash, okay, pay cash. So meaning to say that is already equivalent to cash, and then later on, that same check was delivered to you, okay? Your check was delivered to you, so there was already confusion. You're now the obligor or the creditor of yourself, as well as at the same time credit of yourself. Josie is Tonia's co-maker. So this was also mentioned or covered during our exams. You already got the answer to that. Number 26, which best exemplifies this case? So your rent is due on the 15th of July and you have an obligation to pay rent. Performance is held in abeyance, meaning to say your performance is suspended until the arrival of the date, which is 15. So your performance will depend on the happening of the event. So if that's the case that your performance or your obligation will only happen after the arrival of the event, that's July 15, which of the following is then the correct answer to this? So is it suspensive condition or resolutory condition. When you say resolutory condition, the happening of the event actually extinguishes mahuman na imo obligation. When you say suspensive condition, the happening of the event is the reckoning point when you would start to perform your obligation. So which of these two is the correct answer you choose? C or D? Number 27 to 29. Letter A lists his premises. Okay, his apartment permit to SUV. There was a stipulation that there is no need for them to resort to court. Should be fail to pay his rentals for 2 consecutive months. So that was the stipulation in the contract of peace. Now what happened then was he failed to pay the 2 months of rentals and he was eventually evicted from the premises. B now goes to court for damages because according to them he was not given his day in court. So you have to decide. The answer to this, of course, is that A's action is correct, okay? Because it was expressed in the contract that they should no longer have to resort to court for action, okay? Should the other party violate the terms of the contract. And then 30 to 32, okay? This is when you have to check if the other party is still liable to perform the thing that was lost due to force majeure. Okay, so we have to choose which among the choices is the correct answer. Okay, so we have here no longer liable. Okay, he or she is no longer liable. So you have to choose between B and what else? No longer liable. So you can only have B. Okay, because of force majeure. And then we have 33 to 34. On December 20, 2020, so William binds himself to pay Jacob the amount. So if you will notice in this particular question, I have also covered this during the midterms. There was no mention about when William would pay the amount of 20,000 to Jacob, right? So if the parties to a contract, since if there's a contract in this case, even if it was not written, because the contract could be verbal or written, as long as the essential requisites are present, there was no mention here when he should pay. So it simply means that he should pay Jacob the amount of 20,000 when he demands payment. Okay, anytime. So this is a clear case of pure obligation. So we have to choose among the choices which is the correct one. Okay, so we have here with number 35. So this is an example of pure obligation when the obligation is characterized by being immediately due and by lack of burden of time. There's no time mentioned in pure obligation. It is demandable at once. Number 36. Suppose John executed a promissory note to pay Leon. So the date when he should perform his obligation to pay the amount of 1 million is May 23, 2021. But before the arrival of this date, May 23, 2021, okay, Leon, the creditor, sensed that John did not satisfy his obligation. He approached him for the alleged novation, okay? Alleged novation of the obligation, because according to him, he could not pay. Okay, he sensed that the debtor, in this case, John, would not be able to pay the amount on the agreed date. So the creditor told him that, why not you pay it in 4 installments? Well, 4 installments starting from the month of February to May. Now, is there really novation in this case? Okay. So in this case, you look at the term here, novation. When you go back to your module, you check here about novation, and you'd be able to see here that there are actually requisites for novation. So again, novation is a mode of extinguishing obligation. You have to check if these three are present in the case. So, was there a change in the object or principal condition? Was there a substitution of the person of the debtor or subrogation of a third person in the rights of the creditor? In this case, there was none, right? Because the condition was still there. to pay the amount of 1 million, only that it should be paid by installments starting February to May. Okay, it did not change actually the date of May 23. It says there February to May. So there is no incompatibility between the so-called new obligation with the old obligation. So there is no novation. Okay, so the answer to this is this. No novation because the alleged new terms and conditions did not alter its essence. John is still obliged to pay the amount of 1 million, only that it should be paid by installments starting from February to May. Not June, but February to May. For novation to be effectual, the old and new obligations must be incompatible with each other. Number 37, the following are consequences of solidarity. So when you hear the word solidarity, as in this case, it could be that the solidarity between the creditors, or it could be the debtors in solidum. So regardless, okay, when you talk of this one, okay, you look at the correct answer here. It's supposed to be the following are consequences of solidarity. So it should not be except. Okay, it should be the following are consequences of solidarity. Which of the following then are the consequences of solidarity? So the consequences of solidarity are actually A, B, and C. D is actually not a consequence. Okay, not a consequence of solidarity. So it should be the following are the consequences of solidarity. Or if you insist, the following are the consequences of solidarity except, then the answer would be D. Okay? The following are the consequences of solidarity except. So since the A, B, C are consequences of solidarity, so the answer would be D. Then we go to number 38. Because during our midterms, my answer then was F, okay, A and B and C. Because I failed to check this term here except. So if this is the question except, then the answer would be D. Number 38, which of the following is a consequence of joint obligation? So in joint obligation, okay, consequences of joint obligation, the debtors must pay or must be liable for the proportionate part of the entire debt, not the entire loan. Okay. Number 39, true or false, acceptance must be made during the lifetime of the donor and the donor. Yes, it should be done during the lifetime of the donor and the donee, acceptance of the donee. Because when you say donation, there's actually burden involved on the part of the donor to accept the subject of the donation. Why? Because there could be in the deed of donation, the donee should pay the real property taxes of the parcel of land which is subject of the donation, or he should pay for the extrajudicial settlement of the estate of the donor or something like that. Number 40, mode of extinguishing obligation. So when you say mode of extinguishing obligation, we have here 15. So you go to your modes, okay, of extinguishing, okay. So we have your modes of extinguishing obligations. There are 15. So you check here if the choices here are indeed modes of extinguishing obligation. So when you say fulfillment, condition of the fulfillment of which extinguishes obligation, you are now faced with these two choices only. Not with these two, because it has something with amendment of the contracts, because the new obligation is incompatible with the old obligation. This one has something to do with payment. Creditor pays the obliger, then the obliger will perform something like that. And then we have here fulfillment of suspensive condition. So we have here expiration, okay? Okay, expiration of the fulfillment of the resolutory term. So when you say resolutory term condition, the happening of the event extinguishes the obligation. Next, this is a kind of contract which defines a contract not as an end by itself but as a means. So when you say this one, this is actually a preparatory contract, because in preparatory contract, you still look, for example, when you go buy a piece of land or a house and lot, for example, Camellia, okay, Camellia housing, for example, Camellia land, Camellia property, okay. So they have this preparatory contract. You have to sign this contract, and later on, when you are able to pay the the equity, for example, equity, then you can start paying for the amortization. It could be in-house or via bank financing or something like that. So that is an example of a proprietor contract. The contract that you signed with them, with Camellia, for example, the initial contract wherein you deposit your earnest money. Okay, your earnest money is not actually the contract itself. It is just a preparatory contract for another contract which you would be speaking with them once you will be able to apply the equity, for example. So that's a preparatory contract. Number 42, a contract is defined according to the risk where equivalent values are given both by parties such as sale, barter, or lease. So when you have this one, aleatory contract, this is an example, the contract wherein that you see for insurance, okay, insurance contracts. And then we have commutative contract. This is an example of a contract wherein values, okay, equivalent values are given by both parties because you don't really just give the amount. Okay, you partake, for example, the value or the amount that you have to pay is 60 pesos. That is the value of the object or the thing that you're gonna buy from another person. So there's equivalent values given by both parties. Or trade or barter or lease, okay, there's an equivalent value that you have to consider, that the parties have to consider in their contract. So that's a commutative contract. Sale, barter, or lease, commutative contract. 42 to 43. So this is a case wherein Johnny, yes Papa, and Baby Shark executed a MOA or Memorandum of Agreement. Memorandum of Agreement, this is an example of contract. So in this case, the subject property here was a 4-hectare land situated in Angeles, Pampanga to be developed as a tourist destination. The other party wanted to have his secretary, Attorney Mary Lam, to be present during the drafting, only the drafting of the agreement, because according to him, he should be there, she should be there, so that his rights would be protected. Is that true? Because is that supposed to be the case? Attorney Mary Lam said that she need not be there, because as long as the parties, Johnny, yes Papa, and Baby Shark, in their MOA would agree or stipulate there the terms, conditions that are convenient and are not contrary to law, morals, good customs, public order, public policy. So Attorney Mary Lam is correct, okay? Even if she was a retained lawyer of the other party, as long as the party is mindful of the stipulations, terms, and conditions of the contract, and they did not violate any laws, morals, good customs, public policy, or public order, then the contract is okay, because we have here the principle of autonomy of contract. So we have the liberty, freedom to contract. Number 44 to 45. So the choices here are very long. It's just that this is a case wherein another party executes a lease contract for 5 years with another party, Diego, over her two-door apartment. So in that same contract, it was stipulated that there's another person, third person, Teodora, who would collect the rent from Diego when or once Dora fails to collect. Dora in this case was the lessor, okay? When the lessor fails to collect the rent, the third person, Teodora, would collect the rent. Now it happened that Dora died before the end of the lease. So Dora was single. She had no child. She was childless at the time of her death. So the following month, the third party stipulated in the contract, Teodora, collected the rent from Diego, but Diego told her that she has no right to do so because she's not a party to the contract, because it would be violated the reciprocity of the contract, the liberty to contract, etc., etc. So this is a case wherein you have to think if Teodora has the right to collect, being that she is not a party to a contract of lease between Dora and Diego. Now, since Teodora was mentioned in the contract of lease as the third party, who will collect the rent for Dora should Dora fail to collect the rent from Diego? This is a case of stipulation pool B. So this contention, Diego's contention, is wrong. Because although the general rule is that contracts take effect only between the contracting parties, their signs and ears, There's an exception to the rule wherein there's a stipulation in favor of third person, which is very apparent in their case. Okay, there was a stipulation that Theodora would collect rent from Diego. Number 46. This is a case of stipulation po O3. Okay. 47 to 48, Keanu was a BSBA second year student at BSU. Now, in order to make ends meet, Keanu engaged the buy and sell. Now, in this case, Keanu hired a minor, 14-year-old Sandra. And all of his clients knew that Sandra was a minor. Mr. Singson, one of his clients, okay, his very long-time client, told Keanu that Sandra sold him a piece of laptop, which turned out to be defective. Now, Mr. Singson wanted to collect or wanted to be reimbursed for the amount that he paid to Sandra. At that time, Sandra was nowhere in sight because she called in sick. When Mr. Singson went to Keanu said that he's not liable and he still has to ask Sandra about the incident. So what is the proper thing to do? If you were the ones to decide this case, what could be your decision? So in this case, Keanu is not liable. Okay, Keanu should not be held liable. Although all of his clients know that Sandra is his employee, we have to check again his line of business. His line of business is not the selling of laptop. His line of business is buy and sell of second-hand cars. Okay, so the selling of laptop is totally different from his line of business, which is buy and sell. And also, in this case, Sandra is known to all of his clients to be a minor. So Mr. Simpson is actually stopped from denying that he didn't know that Sandra was a minor and he was talking to a minor, or he's executing this contract of sale with a minor. So the correct answer to this question is Keanu should not be liable. So before you execute any contract with another person, make sure that the person has the consent or is capacitated, or consent, that he has the consent to enter into a contract. Because in this case, for example, if you are executing a contract or a minor sells a thing to you, an object to you, and then later that object turns out to be defective, then it would be your loss. Simulation of contract refers to the following. Okay, so you have to check which among the following is the correct answer to this. Simulation of contract is that when you try to defraud another person, okay, there's no contract at all when you say simulation of contract. You just made it appear that there was a contract when in truth and in fact there was none. There was no contract at all. So simulation of a contract is A and B, okay, and then D. This letter C is not an example of simulation of contract, because this is something to do with falsification of a document, okay, falsification. And then we have here number 50. This refers to any property or right not currently existing, which a person may inherit in the future. So of course, there's a term there, inheritance, and then future. So it has something to do with future. So that's the end of activity 1, multiple choice questions equivalent to 100 points. That's 50 times 2. Now let's proceed to activity 2. This is essay questions. Total points is 20 points. For essay number 1, it says here, under the law, legal subrogation cannot be presumed. So what is legal subrogation? You check your module and then you type in there the term legal subrogation, and then you will have this. The general rule is that legal subrogation cannot be presumed. The exceptions to that are the following. We have number 1, creditor pays another creditor who is preferred without the debtor's knowledge. When you say subrogation, one person would take the shoes of another person. Sulod siya sa shoes ay another person. So if a third party would go to the creditor and then tells the creditor that he would be the one to pay for the debtor. So now by legal subrogation na to, i-check nimo. 1, creditor pays another creditor who is preferred without the debtor's knowledge. Third person is not interested in the obligation pays with express or tacit approval. So, yan kwan is gratuitous na gini siya. Not interested din siya, because when you say the third person is interested, okay, interested, dili gid na siya nga kanang ordinary lang legal subdivision ang mitabo. Even without the debtor's knowledge, so wala kani siya is without the debtor's knowledge kini. Kani siya even if there was the debtor's knowledge, it was expressed for tacit approval, but then the third person is not interested. Wala siya ikuan sa obligation because he would not demand payment or reimbursement from the third person. Okay? And then the other one is even without the debtor's knowledge, a person interested in the full payment obligation pays without prejudice the effects of the condition. So those are the exceptions to the general rule that legal obligation cannot be presumed. That's for number 1 essay question. Then for the second essay question, why are active subject, passive subject, prestation, and victim jury called essential elements or requisites of obligation? So the answer to this is that they are called essential elements because absent one of these elements, there could be no obligation. So that would be the end of our finals examination, and I hope that all of you were able to answer, okay, or remember the answers to the questions. Please be reminded that those who were exempted in the final examinations did not, of course, comply this final examinations next week. But I will not stop you if you will help or assist or aid your classmates in answering the Google form for the final examinations. For those who would be answering this on their own, please have your finals module with you. Since this is an open notes examination, you can ask questions from your classmates. You can use their gadgets, but please make sure that you are signed in your Google Mail account because we are using Google Forms, ladies and gentlemen. So again, I hope that you will be able to get the perfect scores because I already gave you the correct answers actually to this final exam questionnaires. So next week, May 19, 2021, don't forget to answer our final exams. For those who are not exempted, take the final exams. Please make it. Please answer during the scheduled time. No more retakes. No more, please. Okay. No more reset of the final examinations. That will be the end of our semester, second semester 2021. I would like to thank you all for joining me during our virtual discussions, online discussions, and for still not losing your hope to finish your course BSBA in Bukidnon State University. So I hope that you were able to follow our discussion, and if you have some questions, please do raise them in the proper venue in our Google Classrooms or our official group chat in our messenger. Okay, Facebook Messenger. That will be all, ladies and gentlemen. Thank you very much. And God bless you all. See you next time. Goodbye.